Deputy Registrar, could you please open these proceedings?
Thank you, Mr. Justice Witt. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Guyana, judgment delivery in CCJ Appeal number 9 of 2020 between Sheekela Kanhai, Evie Kanhai, Miguel Gutierrez, and Basantie Persaud. The members of this afternoon's panel are Mr. Justice Witt, presiding judge.
Good afternoon, Counsel.
Mr. Justice Anderson.
Good afternoon, Counsel.
Madam Justice Rajnath Lee.
Good afternoon, all.
Mr. Justice Barrow.
Good afternoon, all.
And Mr. Justice Jamadar.
Good afternoon, everyone.
May we have the appearances, please? Thank you.
If it pleases Your Honor, Rajendra Kunai, Senior Counsel, Sohan Kunai, and I, Naresh Kunai, appear for the appellants in this matter, Sheekela Kanhai, Evie Kanhai, and Miguel Gutierrez.
May it please Your Honors, John Lindner for the respondent. My associate, Ms. Gwendolyn Bristol, is also in attendance. She is on record with the Court of Appeal, and I conferred with the Deputy Registrar. She said she can sit in, but she won't take part, so to speak.
Thank you very much. The court has come to a judgment in this case. I will read a summary, which is not intended to be a substitute for the reasons of the court or to be used in any later consideration of these reasons. Iris, who went through life with many surnames, but we call her Iris, the mother of Fletchman, the common law husband of the respondent, signed a written agreement with her brother Carton Sobers in 1965 to lease sublot X, which was a portion of Sobers's property on the west half of Lot 80 Duncan Street, Newtown, Kitty. The agreement was said to be for a term of 99 years, but it took effect and remained as a tenancy from year to year, pursuant to Section 6, Paragraph 3 of the Landlord and Tenant Act, as it was never executed. From the time of the agreement to now, sublot X has been in the consecutive possession of Iris Fletchman, now both deceased, and the respondent. In 1992, Gladstone Alert, who appears to have obtained the property from Sobers, sold it to Mr. Kanhai, the husband of the first appellant. After Mr. Kanhai died, the first appellant conveyed the property to her daughter and son-in-law, the second and third appellant. After the dismissal of an action for possession of sublot X brought in 2007 by Mr. Kanhai against Fletchman, the latter sought a declaration of titles to sublot X, which was granted by the Commissioner of Title to the respondent after Fletchman's death. The Court of Appeal dismissed the appeal and the appellants against that of the appellants against the decision, and the appellants then appealed to this court. The court found that Iris had been given possession of sublot X by Sobers under the agreement, and that this possession was maintained by Iris and continued by Fletchman and the respondent. In such a case where possession held by a tenant moves from being a possession with the consent of the landlord to one without such consent, the nature of the possession does not change, except that for limitation purposes it becomes adverse. In that context, it is therefore not required to establish factual possession and intention to possess in such a case. Though Section 9, Paragraph 2 of the Title to Land, Prescription and Limitation Act provides that for adverse possession, time begins to run after the first year, where there is a tenancy from year to year without a lease in writing. The court, in light of Section 3 of the Act, did not assume that Iris's position had ever been adverse. She was always in possession with the consent of Sobers, as impliedly acknowledged by her in her last will. Further, since she was never required to pay rent, there was nothing to indicate to Sobers when a right of action would have begun to accrue against him. Strict application of Section 9(2) may, in such a case, therefore, lead to arbitrary deprivation of property contrary to Article 142, Paragraph 1 of the Guyana Constitution. The court, however, held, agreeing with the Court of Appeal, that the agreement between Iris and Sobers, being a personal contractual relationship, expired upon Iris's death in 1990. As such, time at least began to run in 1990, and since there was nothing to interrupt the running of time prior to 2002, the title of Sobers in relation to Sublot X expired in that year, and Fletchman became entitled to a declaration of title to Sublot X. And therefore, the court reached the following decision, that the appeal is dismissed. As with respect to the costs, the court understand that parties or counsel were in conversation to reach an agreement on costs. So before I pronounce anything on that, I would like to know if you have reached that agreement.
Yes, Your Honor, Mr. Kanhai here. Counsel and I have discussed, and we have agreed that the security of costs lodged by the appellant be treated as costs in this matter.
And how much is that exactly?
750,000.
750,000 Guyanese dollars. Okay, well, having heard that, I will then.
Your Honor, if I may interrupt, kindly.
Yes.
I was wondering if the cost itself, the security was lodged with the registrar of the Supreme Court. And I was wondering whether it may be wise, well, subject to the guidance of the court, that the order be made directing the registrar of Supreme Court to release those monies to the respondent. I don't know whether that would be necessary.
I would be very surprised if that is necessary.
Very well.
And if I may, I have found it very necessary.
You found
it? I've had great difficulty over the years. Unless the order so reflects, we have to then file an application and goes back and forth. So I would support my friend.
Okay, I'm not alone here, so I'm not sure what my colleagues think, but
sorry, Chair, do I get the sense that there is also an agreement that the registrar shall be asked to return the deposit?
Yes, Your Honor, but the registrar will ask that there be some note from the CCJ.
Then, Chair, I would offer the suggestion that your order can go further and say that the court directs that the registrar shall return.
Very good.
As opposed to ordering her.
Yeah.
So, more options.
And this is the registrar of
Supreme Court of High Court of Guyana.
And this is in the custody of the registrar of the High Court, and you want us to direct her to release that amount of money?
Yes, we should.
Question.
To the respondent. Respondent's respondent's representatives.
To the respondent, because we lodged it and we don't want it to be paid to us.
Okay. Well, I think we would not. I'm still kind of surprised that that is necessary, but if you you know the situation on the ground better than we might do, so. The second order will then be that the appellants shall pay to the respondent costs in the sum of Guyanese dollars 750,000 as agreed, and the court direct the registrar of the High Court to release that amount of money which is under her as security for cost to the respondent.
Thank you.
Thank you.
So that is the decision of the court. Is there anything to add at this point in time? I think the point of cost may have been an issue, but that has been resolved now. I have to say, of course, that the judgment reflects or states, as I also mentioned in the summary, that that there was let me see. There was an order. Now I'm trying to find it.
Discontinuation.
Discontinuation, yes. So, but that is only mentioned in the sequence of events. So nothing depends on that. That we are aware that things went further than that, but it's mentioned as just one event in a sequence of events, so that you know that. Okay. Any further remarks?
Not from this side.
Nothing for you. Nothing for you.
Okay, well, thank you very much then. We will issue the order and the judgment quickly after this, after we finish here. So you will get it, I suppose, today.
Thank you.
Thank you.
Madam Deputy Registrar.
Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath-Lee. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Jawala. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all and have a safe weekend. Thank you.
Thank you, ma'am.